43 years on this bench have exposed me to things most people will never witness in a lifetime. Wealthy individuals attempting to purchase their way past consequences. Powerful people leaning on the law with the full weight of their influence. Entitled defendants staring across my courtroom with genuine conviction that the rules were written for everyone except them. But across all of those decades, across every case that passed through my courtroom, not one person had ever looked me in the eye and told me they owned me. That changed on December 18th, 2024 at 9:33 in the morning when a man named William Ashford III walked through my doors in Providence and spoke 3 words that would unravel everything he had spent his life building. You believe you have heard stories about arrogance before. What I am about to tell you will make every one of those stories seem mild. Let me take you back to how this morning began. It was a cold Wednesday in December. My clerk handed me a file that carried all the surface markings of a routine matter. Case number PVD-2024-12-8847, a citation for parking in a disabled space without proper authorization, fine amount of $500. The kind of case I see every week without pause. Someone running late, someone who convinced themselves no one would notice, someone who came in, settled the fine, offered an apology, and moved on. But the file in front of me was not a routine matter because the defendant standing before me was not appearing for his first violation. He was appearing for his 7th. 7 violations, 2 years. The same offense repeated without interruption. The defendant was William Ashford III, 58 years old. A resident of Newport, Rhode Island, with a listed address of 2847 Ocean Avenue. That address required no introduction in this state. Everyone in Rhode Island recognizes it. One of the celebrated Newport mansions, with a publicly recorded property valuation of $67 million. That was not his only property. The file listed additional holdings in Manhattan, Miami, and Aspen. His total real estate portfolio carried an estimated value exceeding $200 million. The foundation of his wealth was Ashford Development Corporation, a real estate enterprise he had constructed across 30 years. Shopping centers, office buildings, high-end residential developments spread across the eastern United States. According to the most recent Forbes Billionaire Index on file, William Ashford III carried a personal net worth of $8.9 billion. Not million, billion. And this man, worth $8.9 billion, had accumulated 7 citations in 2 years for parking in spaces reserved for people with disabilities. The pattern across those 7 violations is worth laying out in full because it tells its own story. January 8th, 2023, disabled parking violation at Newport Town Center, $250 fine, paid immediately. April 19th, 2023, disabled parking violation at Providence Place Mall, $350 fine, paid immediately. July 4th, 2023, disabled parking violation at Waterfire Arts Center, $350 fine, paid immediately. October 22nd, 2023, disabled parking violation at Newport Harbor, $350 fine, paid immediately. March 8th, 2024, disabled parking violation at Brown University, $500 fine, paid immediately. August 12th, 2024, disabled parking violation at Rhode Island Hospital, $500 fine, paid immediately. And then November 30th, 2024, disabled parking violation on Touro Street in Newport, $500 fine. Total paid across all previous violations, $2,300. Every single citation resolved the same way. Payment made electronically, no contest filed, no court appearance, no explanation offered. Just the money transferred and his day continued without interruption. After the 7th violation, I had issued a mandatory appearance order. I wanted to understand what the pattern represented, whether this was a man who did not grasp the law or a man who simply did not care about it. That was the question that had brought William Ashford III to my courtroom on December 18th at 9:30 in the morning. He arrived at 9:33, 3 minutes late. And the moment he stepped through those doors, every instinct developed across 4 decades on this bench told me this was not going to proceed the way most cases do. His appearance alone communicated volumes. The suit he wore was custom-tailored charcoal gray with a subtle pinstripe, the kind of fabric that carries a particular sheen only achievable at a certain price point. My estimate placed it somewhere between $8,000 and $10,000. The shirt beneath it was crisp white with French cuffs, finished with gold cufflinks that caught the courtroom light as he moved. The tie was Hermes, a pattern I recognized, close to $800 on its own. But the detail that anchored everything else was the watch on his left wrist. My son follows the watch market closely and had shown me photographs of this exact model, a Patek Philippe Grandmaster chime, one of the most mechanically complex timepieces ever manufactured. Only 7 were produced in total. The last one to appear at auction sold for $31 million. $31 million to tell him the time he was late arriving to my courtroom. His shoes were Berluti, probably $3,000, polished to a reflective finish. The belt matched them without variation. Every element of his presentation communicated wealth, but more than that, it communicated the expectation that wealth would be recognized and accommodated. He also did not arrive alone. 5 additional people entered with him. 4 of them wore the unmistakable presentation of high-billing attorneys, tailored suits, leather briefcases, tablets, the posture of people who charge $1,000 an hour and consider it reasonable. The 5th person carried a professional camera with a telephoto lens, not a phone. A dedicated camera brought specifically to document his appearance in a traffic court proceeding. 5 people, one of them a photographer, assembled for a $500 parking ticket. His demeanor completed the picture. Most people who walk into my courtroom carry some degree of nerves. They understand they are in a place that holds authority over their immediate situation, and they conduct themselves accordingly. William Ashford III looked bored. He moved to the defendant's table, but did not sit down. He stood with both hands in his pockets and directed his attention at his phone. I called the case. Case number PVD-202-4-12-8847, State of Rhode Island versus William Ashford III, parking in a disabled space without proper authorization, November 30th, 2024. His lead attorney stepped forward. Marcus Whitmore appearing on behalf of Mr. Ashford, Your Honor. We would like to request a continuance to review the citation and prepare our response. I looked at him. Mr. Whitmore, your client received this citation 3 weeks ago. He has had 3 weeks of awareness regarding this court date. What specifically requires additional time to review? Whitmore's expression registered mild surprise, the particular expression of someone who expects requests to be granted automatically. Your Honor, my client manages extensive business interests across multiple states. His schedule operates at a level of demand that most people do not face. We are simply asking for a reasonable accommodation. Mr. Whitmore, every person in this courtroom manages responsibilities they consider pressing. Every person here values their time. Your client will receive the same treatment as every other defendant who appears before me. No special accommodations will be made. Please take your seat. The look Whitmore exchanged with Ashford before sitting down told me everything about their expectations entering that room. I directed my attention to William Ashford III. Mr. Ashford, you are appearing today in connection with a citation for parking in a disabled space on November 30th. I note from your record that this represents your 7th violation for this identical offense within a 2-year period. Is that accurate? He looked up from his phone with the expression of someone mildly inconvenienced by an interruption. Yes, he said. One word. No, Your Honor, attached to it. No acknowledgement of the setting he was standing in. Just yes, delivered with the flat energy of someone answering a question they found beneath their attention. Mr. Ashford, I would like to understand something. You have been cited for this same violation 7 times. Why do you continue parking in spaces designated for disabled individuals when you clearly possess neither a placard nor a permit? He regarded me for a moment. Then he answered, as though the explanation were self-evident to anyone paying attention. Because it is convenient. The room went still, Everyone present staring. I am sorry, I said. What was that? It is convenient. Disabled spaces are consistently located closest to building entrances. I prefer not to walk from distant parking areas, so I use the disabled spaces. They are closer. I sat with that for a moment. A billionaire was explaining to me that the reason he had accumulated 7 violations for occupying spaces reserved for people with disabilities was that he preferred a shorter walk. Mr. Ashford, you are aware that disabled parking spaces are reserved specifically for individuals whose physical conditions require them, people who cannot manage the distances that able-bodied people cover without difficulty. He offered a single-shouldered shrug. I am aware of that, but I pay the fine each time I receive a citation. My payment record is right there in the file. I have paid over $2,000 in fines without any difficulty. That should more than address any inconvenience caused to anyone, more than address the inconvenience. As though the rights of disabled people to accessible parking were a commodity with a price attached. Mr. Ashford, the fine is not a fee that purchases your right to occupy a disabled space. It is a penalty, a deterrent, a mechanism designed to discourage you from repeating the behavior. He smiled. It was a cold, precisely measured smile. Your Honor, with respect, a $500 fine does not deter me. I routinely spend more than that at lunch. The fine carries no practical meaning in my life. So yes, I pay it, I absorb it as an operational cost, and I continue with my day. I routinely spend more than that at lunch. My father sat on this bench before me. He instilled in me a conviction I have carried across every case of my career. Every person who stands in a courtroom stands on equal ground, regardless of what they possess or what they have built. The janitor and the chief executive officer occupy the same position before the law. William Ashford III did not hold that belief, not in any part of himself. Mr. Ashford, do you genuinely understand the purpose these spaces serve? They exist for people using wheelchairs, for people dependent on walkers, for people whose physical conditions make a long walk from a distant parking space a genuine hardship rather than a minor inconvenience. I understand the framework, Your Honor. Then why do you occupy their spaces? If the spaces are unoccupied when I arrive, no one is being denied anything. I am using available space. What happens when someone who needs that space arrives after you have taken it? Another shrug. Then they find somewhere else to park. Then they find somewhere else to park. A person in a wheelchair, a person managing a disability that makes every additional distance painful should simply find somewhere else to park because William Ashford III preferred a shorter walk from his vehicle. The anger I felt was real. 4 decades on this bench have given me the tools to keep it contained and professional, but this was testing those tools. Mr. Ashford, have you given any consideration to the fact that what you are describing is a pattern of selfish behavior, that you are treating your minor preference as more important than other people's genuine physical needs? Something shifted in his face. The boredom gave way to something harder. Your Honor, I take exception to that characterization. I do not come here to be addressed like a child receiving a lesson. I pay substantial taxes in this state. My various enterprises employ 2,400 people. My charitable giving runs into the millions annually. I serve on the boards of 3 hospitals and 2 universities. The contributions I have made to this community over my career have been significant. I have earned the right to make my own decisions. He had used those words, earned the right. The accumulation of wealth and the distribution of some of it had earned him the right to disregard laws designed to protect disabled people. Mr. Ashford, wealth does not purchase exemption from the law. Community contributions do not substitute for basic human decency. He actually laughed, an unguarded, dismissive sound that filled the courtroom. Your Honor, allow me to explain something about how things actually work. Everything gives me the right. Money, influence, power, and connections. I have all of those things in abundance. And in the world outside this building, in the world where things actually get done, those things carry considerably more weight than parking regulations. One of his attorneys began rising from his seat, clearly intending to interrupt the direction his client was heading. Ashford waved him back down. I am being straightforward with you. I have built a business empire worth billions of dollars. I have generated thousands of jobs. I have developed properties that transformed entire neighborhoods. I have contributed tens of millions to charitable causes. I have personal relationships with governors, senators, and chief executives of major corporations. People who operate at that level do not answer to traffic court proceedings. That is simply the reality of how things work. I looked at this man, this person who carried absolute conviction that his net worth placed him in a category the law could not reach. Mr. Ashford, are you stating to this court that you consider yourself above the law? He held my gaze without hesitation. I am stating that laws are suggestions for people who cannot afford to ignore them. I can afford to ignore them, so I do. Laws are suggestions for people who cannot afford to ignore them. I allowed those words to remain in the room. I let everyone present absorb exactly what they had just heard. Mr. Ashford, I have reviewed the full record. 7 violations across 2 years. Every fine paid without contest, without dispute, without a single attempt to challenge the charges. You simply pay and repeat. Why? The cold smile returned. Because it is cheaper than changing my behavior, Your Honor. A $500 fine is not a factor in my financial life. It does not register. I generate more than that amount in passive interest income during the time we have been standing here speaking. So yes, I park in disabled spaces. And yes, I will continue parking in disabled spaces because the financial consequence is completely without meaning to me. He paused. He let his gaze move across the courtroom and then returned to me. And there is absolutely nothing you can do about it. I said very quietly, Is that so, Mr. Ashford? That is exactly so. Fine me $500 and my assistant will have it paid before I reach the parking lot. Fine me $5,000 and it will not affect my afternoon. Fine me $50,000 and it will not affect my week. So go ahead, Your Honor. Set whatever fine you believe is appropriate. I will pay it, and I will continue to park wherever I choose. His attorneys were writing with visible urgency. They understood precisely where this was heading, even if their client did not. But Ashford was not finished. He moved closer to my bench, narrowing the distance between us in a way that was entirely deliberate, and then he delivered what he clearly believed would end the conversation in his favor. Your Honor, you are aware of what I am worth. It is public information in any case. According to Forbes, $8.9 billion. Are you aware of what you earn? I researched it before appearing here today. Rhode Island Superior Court judges earn $189,000 annually. That is a respectable income. But I generate your entire annual salary in approximately 4 hours. Every 4 hours of every day, I earn what you earn across a full year. He allowed that to settle in the room. Then he said the 3 words that would cost him everything. So when I tell you there is nothing you can do about it, I mean that precisely. I own you. The room broke open, gasps from every direction. Someone behind the gallery rail called out in shock. My bailiff, Officer Jackson, stepped forward immediately with his hand moving on instinct. I raised mine, and the room went silent. Mr. Ashford, I said slowly, what did you just say to me? He smiled wider, the expression of someone who believed they had just secured the outcome they wanted. I said, I own you. I own this courtroom. I own this building. My family has been a part of Rhode Island for over 2 centuries. We have held property in Newport since the 1800s. I have personally directed $40 million into this state across the past decade alone. I have the governor's personal number in my phone. I play golf with the mayor on a monthly basis. 3 state senators return my calls the same day I make them. He stepped closer still. So yes, Your Honor, I own you. Your complete annual income is a rounding error in my daily earnings. People at my level are not directed by people at yours. That is not an opinion. That is how the world functions. I sat looking at him for 30 full seconds. This man worth $8.9 billion who had walked into a courtroom and told a judge he owned her. Then I spoke. Mr. Ashford, thank you. The confusion that crossed his face in that moment was immediate. That was not the response he had constructed this entire performance to receive. Thank you for that speech. That extraordinarily revealing, extraordinarily arrogant, extraordinarily ill-advised speech, because you have just made the work in front of me very simple. The smile began its retreat. You have admitted on the record, in front of 40 witnesses, with a court reporter capturing every word, that you knowingly and deliberately violate disabled parking laws because the fine amounts are inconsequential to you. You have stated clearly and without qualification that you place yourself above the law. You have attempted to intimidate a sitting judge. You have invoked your wealth and your connections in an explicit effort to influence the outcome of these proceedings. And you have told me directly that you own me. What I am going to do with that information is this. On the current violation, parking in a disabled space without authorization, on November 30th, 2024, the fine is not $500. He moved to speak. I continued without pause. Under Rhode Island General Law 31-27-2.2, judges are authorized to impose fines up to $50,000 for willful and repeated violations of disabled parking regulations. You have acknowledged that this is your 7th violation. You have acknowledged that it is willful. You have acknowledged that it is deliberate and ongoing. The fine is $50,000. His mouth fell open in a way that suggested his brain had not yet processed what he had heard. Second, I am ordering 200 hours of mandatory community service to be completed specifically with disabled individuals at the Rhode Island Independent Living Center. You will assist people with disabilities in daily tasks, mobility support, transportation needs, and whatever else the center requires. 200 hours. His face had begun to color. Third, your driver's license is suspended for 6 months, effective immediately. If you are unable to demonstrate respect for the rights of disabled people to access the parking that exists for them, then the privilege of operating a vehicle is not something you have earned the right to hold. Your Honor, this is completely your honor. I am not finished. Fourth, this matter is being referred in its entirety to the Rhode Island Attorney General's office for formal review. The statements you have made today, combined with the documented pattern of 7 repeated violations, raise the question of potential criminal charges for deliberate, willful, and systematic violation of state disability accommodation law. His 4 attorneys were simultaneously on their feet, all speaking. I gave none of them any acknowledgement. Fifth and finally, I am issuing a special court order. Should William Ashford III be cited for parking in any disabled space anywhere within the state of Rhode Island at any point during the next 5 years, he will be held in contempt of this court and will face immediate incarceration. A minimum of 30 days in the adult correctional facility. No exceptions and no negotiations. The courtroom was producing more noise than it had at any other point in the morning. I brought the gavel down firmly. Order. I will have order in this courtroom. Silence returned. Mr. Ashford, I am going to extend to you one opportunity. You have 24 hours from this moment to issue a public apology to the disabled community of Rhode Island. A genuine apology, not a statement prepared by a public relations team. Something from you in your words, acknowledging what you did, acknowledging why it was wrong, demonstrating that some part of what you heard in this room today actually reached you. I held his gaze. If you do that, if you produce something that reflects genuine accountability, I will reduce the fine from $50,000 to $10,000. I will reduce the community service from 200 hours to 100 hours. The license suspension remains. The Attorney General referral remains. The 5-year contempt provision remains. But I will extend the same grace to you that you have never extended to the people whose spaces you kept taking. I pause to let that land. If no apology is issued within 24 hours, the full sentence stands without reduction. $50,000 fine, 200 hours of community service, 6-month license suspension, criminal referral to the Attorney General, and 5 years of contempt liability. The gavel came down. You have 24 hours beginning now. Court is in recess. I rose to step down from the bench. That was when William Ashford III made the final and most consequential mistake of that entire morning. He shouted after me, "You cannot do this to me. Do you have any idea who I am? I will have you removed from this bench. I will end your career." I turned back slowly. "Mr. Ashford, you are now in contempt of court for threatening a judicial officer. Officer Jackson, please take Mr. Ashford into custody." "What? You cannot arrest me." Officer Jackson moved forward with 2 additional bailiffs. Ashford stepped back. "Do not touch me. I am William Ashford III. I am worth $9 billion. The handcuffs closed. William Ashford III, worth $9 billion, wearing a $10,000 suit and a $31 million watch, being placed in handcuffs in my courtroom. This is illegal. I will sue this court. I know the governor personally. I will have you removed. Mr. Ashford, every additional threat you make will be added to the contempt charges. I strongly recommend silence." They moved him toward the door. His voice continued to carry down the corridor, still making promises about what his connections would deliver. His 4 attorneys stood frozen at the defense table. After he was removed, something happened that I rarely experience in this room. The 40 people in that gallery rose to their feet and began applauding. Judges do not typically receive standing ovations, but these people had watched a billionaire stand before a judge and declare ownership of her. They had watched him express open contempt for people with disabilities. They had watched him announce that laws existed only for people who could not afford to disregard them. And they had watched him face consequences that treated all of that as exactly what it was. Over the following 24 hours, my phone registered 7 calls: a state senator, 2 businessmen, several attorneys, each one carrying variations of the same message. William Ashford was too prominent, too connected, too important to the state's economy for this kind of outcome. I documented every call, every name, every message, because this was precisely the network of influence Ashford had described from the witness position at my bench. He had told me his connections would protect him. He was about to discover the limits of that prediction. The 24-hour deadline passed. No apology was issued. His legal team had advised him that any public acknowledgement of wrongdoing could be introduced against him in civil litigation. So the full sentence stood in every detail: $50,000 fine, 200 hours of community service, 6-month license suspension, formal referral to the Attorney General, 5-year contempt provision. He appealed every component of the sentence. Every appeal was denied. The appellate judges upheld the sentence in its entirety. The $50,000 was paid. The community service began. His license was surrendered. The Attorney General opened a formal investigation. And then, approximately 3 weeks after the confrontation in my courtroom, my clerk placed an envelope on my desk. Handwritten. No professional letterhead. My name on the front. Inside was a letter from William Ashford III. He wrote about his first weeks at the Independent Living Center, about the veterans who had returned from service without limbs, about young people living with cerebral palsy, about teenagers managing muscular dystrophy. He wrote about listening to them describe what happened when they arrived at a destination and found their space occupied. The appointments missed, the physical difficulty of managing a longer route, the experience of being treated as invisible by people who simply found their designated space more convenient. He wrote these words: "I was wrong, not only in the legal sense, not only as a matter of regulatory compliance, morally wrong. Wrong as a human being in the most basic way a person can be wrong." He stated that he was withdrawing all remaining appeals and accepting the full sentence without further challenge. He also stated that he was establishing the Ashford Accessibility Foundation with a personal contribution of $50 million directed toward wheelchair ramps, modified vehicles, and accessibility improvements for disabled people across the state.